Hello, everyone. Today we have another fabulous webinar conducted by the incredible Alex Barthet of the Barthet Law Firm. I'm Mariella Wagner. I am the founder of SunRay Construction Solutions, a national preliminary notice service and construction software company. Today we are going to learn how to recover your legal fees when you collect a debt. So without further ado, I introduce Alex Barthet.
Thanks, Ariella. Again, my name is Alex Barthet. I'm a board-certified construction lawyer here in Florida. And today we're going to talk about how to recover your legal fees when you have to sue someone to collect a debt, and as well, how to deal with it if someone sues you for claiming maybe that you breached a contract. So let's get started. So today we're going to talk about the two ways, and for the most part, there are really only two ways to recover your legal fees in the state of Florida. I'm going to show you a sample contract provision of what you need to have in your agreement so you can recover legal fees. We'll discuss who is the prevailing party, because it's not always so simple to decide, and I'll answer any questions that you have at the end. Now, with respect to your questions, please make sure to use the GoToWebinar chat box that is available to you, and do not include the names of any people or companies in your question, please. So let's get into it. So in Florida, there are effectively only two ways to recover your legal fees in a case. Number one, if you sue someone for breaching an agreement, or they sue you for breaching an agreement, that agreement needs to be in writing, and it needs to include a provision that says that the winner gets their legal fees from the loser in the case. So that's one way to do it. And we'll get into a little more detail on what exactly that looks like. The second way to recover legal fees in the state of Florida is if you sue someone because they violated a specific statute, a specific law on the books in the state of Florida, and that law says that their winner can recover their legal fees from the non-prevailing party. There are some other ways in the course of litigation that can allow one party to recover legal fees from another, but primarily speaking, these are the ways that legal fees are recoverable in the state of Florida. So let's look a little deeper about at what it means to recover fees because you have a written contract. So there are several key components to this this way to recover legal fees. One, you have to have a written agreement, and two, that written agreement between you and the other party has to say that the winner gets their fees. Here is an example, and there's lots of different ways to write this. Here is one example of such a provision. It says, the prevailing party in any action to enforce this agreement shall be entitled to recover its costs, expenses, and legal and paralegal fees from the non-prevailing party related to the collection suit or other legal action, including arbitration and appeal. So sometimes these provisions are shorter, sometimes they're longer, but they effectively say that the winner gets their fees from the loser. So I said it has to be in writing. So if you come to my business and you sell me something, or I hire you to do some construction work or buy materials from you, and we have a handshake deal, we have no written agreement at all, then if you want to sue me because I didn't pay you, you will not recover your legal fees even if you win. So some nuances to this issue are, well, what if we don't have a written agreement at the time we signed the contract, but when I sent the invoice, it said that the winner had to pay their fees. Much harder to prove that there was an agreement on fees if you just have it in your invoices. A better scenario would be that you sent a purchase order, and the purchase order had terms and conditions, and then you filled the purchase order and I paid for them or some of the items on the purchase order, and now we can show, well, the terms and conditions on that purchase order were part of the understanding between the parties. So even though it wasn't signed, there is at least some indication that there was an agreement to the provisions. By far, the best way to have a right to recover legal fees from a contract is, one, that it's in writing, and two, that it's signed and it includes this provision. So keep that in mind when you're reviewing your contracts. So let's talk about the second situation, suing someone for violating a statute, and that statute says that the prevailing party is entitled to their legal fees. So Florida Statute 713.29 is the lien statute that deals with the recovery of legal fees. So as you likely know, if you record a lien on a piece of property or make a claim on a bond because the contractor has issued a payment bond, you have certain rights. One of those rights found in Chapter 713.29 is that you are entitled to recover your legal fees if you prevail. So Florida Statute 713.29 says, in any action brought to enforce a lien or to enforce a claim against a bond under this part, the prevailing party is entitled to recover a reasonable fee for the services of her or his attorney for trial and appeal or for arbitration in an amount to be determined by the court, which fee must be taxed as part of the prevailing party's costs as allowed in equitable actions. So if you record a lien on a piece of property and you win, one of the things that the judge may award to you is not only the amount that they determine is due under your agreement for the improvements you performed, but also the legal fees you incurred to prevail on the lien. It sounds pretty simple, but there are some things to keep in mind. Number one, most cases settle before trial. At any given time in our office, we have several hundred cases that are going, and almost all of them settle prior to the actual trial date, prior to the judge issuing an order that someone wins and someone loses. In those situations, a negotiated settlement usually includes some negotiation with respect to the recovery of legal fees. Everyone has spent legal fees up to that point, and as part of the compromise, people usually are also negotiating the right to recover legal fees. So I'll give you a few examples of this. So when we represent a supply house, for example, that recorded a lien on a piece of property, maybe we are the plumbing supply house for a plumber who did work for a contractor who has a contract with an owner. Our client, the plumbing supply house, records a lien, and now the owner of the property has to deal with it. In that case, usually we have a much better right to recover fees if we have timely sent our notice to owner. So using SunRay to do the notice, to do the lien, increases the likelihood that you're going to recover your legal fees, because unless there was an issue with maybe the delivery, maybe you delivered the wrong materials, maybe there were counter pickups, so you can't show they were incorporated. But assuming all those pieces work out, you have a pretty good right to recover fees, and in most of those cases, we recover all of the fees due to the other party, due to the supply house, because the owner has very little right to get out of it. However, if there's a contested matter, maybe between the plumber and the contractor, at the end of the day, those cases usually get settled and fees usually are compromised to make the case go away, to reduce the risk of an adverse outcome at trial. Next, a party may prevail in some theories of the case, but not others. And as a result, the court is going to decide who prevailed on the significant issues in the case. And the party that prevailed on the significant issues, if there's a right to recover legal fees, will be the prevailing party. So for example, if you have a lien case, a lien claim and a breach of contract claim, and the court finds, you know what, the breach of contract claim, no one really prevailed, but you did prevail on the lien claim, then you would be able to recover your legal fees under the lien claim, but not necessarily the time that was spent on the contract claim. So in the old days, more than a decade ago, the rule on the lien was if you won $1 on your lien, you would get your legal fees. That rule has changed over time. And as a result, you have to prevail on the significant issues in the case, and the person that determines what those significant issues are and who prevailed on them is the judge. So we are seeing more and more courts and judges not necessarily award the prevailing party all of his or her fees all the time. So keep that in mind. So let's talk about a few best practices, and then we'll answer any questions you have. Recognize that your ability to recover legal fees may drive the decisions that happen in a case, or may drive whether you file a case at all. I was on the phone yesterday with a client who is a cabinet maker and installer, typically doing much bigger work, but also does some work for homeowners. And they installed a $30,000 kitchen, and the homeowner paid in installments on their credit card. And once the work was done, the last installment that was paid, they put a charge back on their credit card for $5,000. So the credit card company took the money back from the cabinet installer, and now the cabinet installer is owed $5,000. Not an insignificant amount of money, but unfortunately, this cabinet installer does not have a lien, on the property, and did not have a written agreement that said the winner gets their legal fees. So as a result, if they hired someone or proceeded with a legal case, they may recover their $5,000, but maybe they'll spend $2,000, $3,000, $5,000, $10,000 in legal fees to get there. And as a result, they would be worse off, not better off. So my advice was, unfortunately, aside from maybe sending a demand letter to try to get their attention, actually filing a lawsuit may be less productive. You may pay me money, but that's not the goal. The goal is, how do you recover your money? It was a good lesson for them to include a fee provision in their contract, which they've decided to do from here on out. So always be cognizant of the right to recover legal fees, and make sure that if you are talking to an attorney, that you understand, if I'm proceeding with a case or defending a case, what is the ability to recover legal fees in this case? When you're reviewing your contract, always include a provision that the prevailing party is entitled to recover legal fees, so that when, or I should say if, the situation were to occur, you know that if you have to hire a lawyer, you can recover your legal fees. So if anyone has any questions, now's the time to submit it. Ariella, do we have any questions?
So far, we do not have any questions. However, if you would like to ask a question after the webinar that you think of 5 minutes later, once the webinar is over, feel free to reach out to Alex, and you could see his contact information. Of course, we have the calculene, the fabulous calculene. We have to talk about that beforehand.
So yes, if you want to stop calculating your lien and notice to owner deadlines on your fingers, you can download the calculene app, and it will do all of that calculation for you. We also have our last webinar of the year. We do this once a month. Our new calendar will be up shortly for 2020. But on December 12th from 9 to 9:20, we'll talk about how to recover small amounts of money on your own so that you don't have to hire a lawyer. We're going to explain the small claims court process, how to get the information you need to bring the action yourself. I will demystify it a little bit. I advise clients on a regular basis, bring an action on your own. Train someone in your office to go ahead and learn how to do this, so that when someone owes you a small amount of money, you don't have to hire a lawyer. You can do it yourself. If you go to sunraynotice.com/education, you can do two things. You can sign up for all of our future seminars and webinars, but you can also watch all of our past webinars that we've had for the last several years. And here is the slide you were talking about, Ariella, our contact information. If you have any questions about this topic or anything else, send Ariella or me an email. We'll be happy to get back to you right away.
Well, Alex, another fabulous webinar. And again, if anyone has any other questions, feel free to reach out to us at any time. And I hope everyone has a sunny day.
Thanks. Have a great day, everybody.